What if I told you the family immigration process you've been relying on for years is about to change dramatically? Thousands of families across America are waking up to a new reality. Bringing their loved ones to the United States just got significantly more complicated. In January 2026, the Trump administration announced major changes to I-30 family petition rules that could affect your ability to sponsor parents, siblings, spouses, and children. If you have a pending petition or you plan to file one, the next few minutes could determine whether your family stays together or remains separated for years to come. Hello, everyone. You're watching Policy and Pathways, and I'm your host, bringing you the most important updates on American immigration, visas, and policy changes that directly impact your future in the United States. Today, we're breaking down the latest announcement on family-based immigration and the I-130 petition process. These changes are expected to take effect in early 2026, and if you don't understand what's happening, you could face massive delays, denials, or even long-term separation from your family members. Watch this video until the very end. Take notes and please subscribe to Policy and Pathways so you never miss an important immigration update that could change your life. Let me start by explaining what the I-130 petition is and why it's so critical to family immigration in America. The I-130, officially called the Petition for Alien Relative, is the foundation of family-based immigration to the United States. This is the form that U.S. citizens and lawful permanent residents file with USCIS to establish a qualifying relationship with a foreign family member. Once the I-130 is approved, it confirms the relationship is valid and your relative can then apply for an immigrant visa through consular processing, or, if eligible, adjust status inside the United States to become a permanent resident. The I-130 covers different family relationships, including immediate relatives like spouses, unmarried children under 21, and parents of U.S. citizens, as well as preference categories for siblings, married children, and adult children. For decades, family reunification has been a cornerstone of American immigration policy. Millions of immigrants have used the I-130 process to bring their loved ones to America legally. But in January 2026, major policy changes were announced that are reshaping how these petitions are processed, evaluated, and approved. These are not minor technical adjustments. These are significant shifts that reflect a broader enforcement-focused approach and an effort to reduce overall immigration numbers, particularly in family-based categories. First, there is significantly increased scrutiny and heavier documentation requirements for I-130 petitions. Under the new guidelines, USCIS is requiring petitioners to submit substantially more evidence to prove the legitimacy of family relationships. In the past, basic documents like birth certificates, marriage certificates, and proof of the petitioner's citizenship or permanent residency were often sufficient for straightforward cases. Now, under what's being described as enhanced vetting, even routine I-30 petitions may face much more intensive review. USCIS may ask for extensive documentation of the relationship history, stronger proof of financial interdependence for spousal petitions, detailed affidavit from third parties, photo evidence spanning the full relationship timeline, and in many cases, certified translations of foreign documents from approved translators. In practical terms, preparing an I-130 petition becomes more complex and more expensive. Many people may feel they need an immigration attorney or a qualified professional to help compile the evidence correctly. You may need paid document translations. You may need affidavit from friends, family members, and colleagues who can attest to your relationship. And even after submitting all of this, processing times may rise because officers will spend more time reviewing each petition. Cases that used to be approved in 6 to 12 months may now take 18 months or longer. And that's only the I-30 stage, not the entire immigration process. Second, there are stricter financial requirements for sponsors. When you file an I-130 petition, you're not only proving a family relationship, you're also committing to financially support your relative, so they don't become a public charge in the United States. This is typically done through Form I-864, the Affidavit of Support. Under prior standards, the sponsor's income requirement was commonly based on 125% of the federal poverty guidelines for the household size. If you didn't meet the threshold, you could often use a joint sponsor. Now the financial standards are tightening. Proposals indicate the income threshold could increase to 150% or higher. The use of joint sponsors may be limited, making it harder to qualify if you personally don't meet the income requirement. Assets may be scrutinized more aggressively, and having assets may not be enough to overcome an income shortfall unless you can prove they're liquid and readily available. Here's what that means for real families. If you're a U.S. citizen sponsoring only a spouse, you might currently need around $28,000 per year, depending on the guideline chart and year. If the threshold moves to 150%, that number could jump to roughly $33,000 or more. If you're sponsoring multiple family members, like a spouse and parents, the required income rises quickly. For a household of 4, you could be looking at $50,000 or more annually. Many American families simply don't earn that much, especially in lower-wage industries. The result is that working-class and lower-middle-class sponsors may find it much harder to bring loved ones through family-based immigration. Third, there are expanded grounds for denial and increased use of requests for evidence, also known as RF. An RF is a notice from USCIS asking for additional information or documentation before they make a decision. The rate of RFS has increased, and under the new 2026 approach, USCE officers may have broader discretion to question the bona fides of relationships and deny petitions based on concerns that can feel subjective, such as whether a marriage seems genuine, whether family ties appear strong enough, or whether the petitioner has shown enough commitment to supporting the relative. The administration is also pushing USCIS to take a harder line on inconsistencies, even small ones. A minor date error, a different spelling of a name across forms, missing a prior address from years ago, issues that might previously have been corrected easily, can now trigger RF or even denials. The message many families are receiving is that the process is being made more difficult, more expensive, and more stressful, which may discourage people from applying at all. Fourth, there may be more difficulty for family preference categories due to the priority date system and visa bulletin retrogression. Family preference categories are limited by annual numerical caps, which creates backlogs, especially for countries with high demand like Mexico, the Philippines, India, and China. Your priority date is the date USCIS receives your I-130, and that date determines your place in line. You can only proceed with the immigrant visa stage or adjustment of status when your priority date becomes current according to the monthly visa bulletin. Under the current direction, many are seeing deliberate slowdowns in how quickly priority dates advance. So even if your I-130 is approved, you may still wait years longer before your family member can actually immigrate. In some sibling categories, wait times already exceed 20 years for certain countries, and under slower movement, those waits could stretch to 25 or even 30 years. Fifth, there is increased scrutiny of adjustment of status applications, including cases involving immediate relatives already in the United States. Many people file I-130s for spouses or children who are already in America, on tourist visas, student visas, or sometimes with complicated status histories. Historically, immediate relatives of U.S. citizens, spouses, parents, and unmarried children under 21 often had more options to adjust status if they met requirements, even if they had certain prior issues depending on the facts. Under the new approach, USCIS is taking a stricter view of overstays, unlawful presence, and suspected fraud. Even immediate relatives may face longer processing times, more interviews, more investigation, and higher denial risk. For example, if someone entered on a tourist visa and then married a U.S. citizen shortly after, USCIS may suspect misrepresentation and may investigate the case more aggressively. Officers may look for any reason to deny, including gaps in documentation, minor violations, or anything they interpret as fraud. Let's talk about how these changes can affect specific family categories. If you're a U.S. citizen sponsoring a spouse, you should expect heavier evidence requirements to prove the marriage is real, more in-person interviews, and detailed questioning about your relationship, daily life, finances, and plans. They will be looking for inconsistencies. If you're a U.S. citizen sponsoring parents, you may face the same enhanced documentation and financial review and any prior immigration issues your parents may have. Previous overstays, unlawful presence, old denials could be examined more critically. If you're a lawful permanent resident, sponsoring a spouse or unmarried children, the situation can be even more challenging because you're in preference categories with longer waits. And USCIS may also scrutinize whether you're properly maintaining your own permanent resident status. For siblings of U.S. citizens, the category is already the slowest, and there has been discussion about eliminating it altogether. Even if that would require Congress and hasn't happened, the fact it's being discussed shows the direction of policy. Now, what can you do to protect your family's immigration prospects? First, if you're planning to file an I-130 petition, file as soon as you can. Your priority date is locked in on the day you file, and every month you wait can add more time to an already long process. Second, prepare the most complete and well-organized petition package possible. Don't submit only the minimum. Include strong evidence of your relationship, detailed affidavit, photos, communication records, and where relevant financial documents showing joint accounts, shared responsibilities, or genuine interdependence. Third, seriously consider hiring an experienced immigration attorney. With higher scrutiny, professional guidance can help you avoid mistakes. Identify weak points before USCIS finds them. Prepare for interviews, and respond properly to RFS. Fourth, make sure you meet the financial requirements. Review your income carefully. If you're close to the threshold, plan early. If joint sponsorship is still an option in your situation, line it up in advance. If you plan to use assets, be prepared to prove they are liquid, accessible, and properly documented. Fifth, be accurate and truthful on every form. With stricter review, false statements or material omissions can lead to denial and potentially serious consequences. Even honest mistakes can create delays, so triplex check every detail before submitting. Sixth, if you receive an RF, respond quickly and thoroughly. You may have only 30 to 60 days. Provide everything requested, address each concern directly, and if you're unsure how to respond, get legal help immediately. It's also important to understand your rights. If your I-130 is denied, you may have the option to appeal or file a motion to reopen or reconsider. But these steps are time-sensitive and technical. In some situations, it may be better to correct the issues and file a new petition rather than appeal. The best choice depends on the facts of your case. So legal advice matters. Also, stay informed. Immigration policy can change quickly, and rumors can seriously damage cases. Follow reliable sources like Policy and Pathways, where we break down changes clearly and explain what they mean for real people. Don't rely on unverified social media posts or someone told me advice. If you filed an I-130 before these standards took effect, understand that USCIS may still apply updated scrutiny to pending cases. If you get an RF asking for more evidence, that can be the new approach showing up in your case, and you must respond strategically. And remember, family-based immigration isn't the only path. Depending on your situation, you may want to explore employment-based options, the diversity visa lottery, humanitarian pathways, or other lawful strategies. Each has its own requirements, but it's worth understanding all possibilities. Let me also warn you about common mistakes that have become even more costly under stricter rules. Rushing the petition and submitting a weak package, hiding or failing to disclose past immigration violations, not maintaining legal status while a petition is pending when required, and failing to update USCIS about address or major changes, which can cause you to miss important notices. The overall approach we're seeing represents a major shift away from family reunification as the central principle. Whether you agree or disagree, understanding the direction matters because it helps you plan realistically. If this direction continues, you should expect continued tightening, more enforcement, and more obstacles in the family-based process. I want to be honest, these changes can make family immigration significantly harder. Many families may face longer separation. Some petitions that might have been approved in the past may face denial now. Financial barriers may block some sponsors entirely. That is the reality many are facing in 2026. But don't lose hope. Thousands of families still succeed every year. With careful preparation, strong evidence, patience, and good legal guidance, it's still possible to reunite legally. It may require more effort, more documentation, and more time, but it can be done. Here on Policy and Pathways, we're committed to helping you understand these changes and make smart decisions. We'll continue monitoring policy updates, breaking down new announcements, and explaining what they mean for you. If you found this video helpful, hit the like button and share it with anyone going through the family immigration process. Subscribe to Policy and Pathways and turn on notifications so you don't miss the next update. Policies can change quickly, and staying informed is one of the best protections you have. Drop a comment below with your questions, or tell me what topic you want next. I read the comments, and your feedback helps me create content that addresses your real concerns. Remember, knowledge is power in immigration. The families who succeed are the ones who understand the rules. Prepare thoroughly and act strategically. If you're planning to sponsor a family member, start preparing now. Gather your documents, review your financial situation, and if needed, consult with an immigration attorney. The sooner you act, the better your chances. This is Policy and Pathways, and I'll see you in the next video. Stay informed, stay prepared, and don't give up on bringing your family together. Take care.